Hello, everyone. Thanks for joining us for the last session of our free lunch webinar series, Farmland Leasing. We're grateful to have Dr. Chris Clark once again from UTIA joining us as today's instructor. A few housekeeping items. Please leave your microphones on mute and video off during the session. If you like to locate the chat box right now, you can type your name and location to help me record attendance. You can use the chat box at any time during the session to submit your question. I am recording the session, so if you like to view it again or share with someone else, feel free to do so. And I'll ask you to answer 2 questions at the end to help me record feedbacks. So if there are no questions at this time, let's dive into today's session.
Good afternoon, everybody. Which today's session is legal considerations, and I guess we're going to start with the traditional disclaimer to say that any information provided is not intended to be legal advice, nor is it intended to be a substitute for legal services from a competent professional. So this is meant as education, and we're going to talk in generalities, although I do encourage questions. But certainly none of this would substitute for competent advice from a competent professional who is intimately familiar with your particular circumstances. So having said that, getting that out of the way, just starting very broadly and very basically with a legal overview of farmland leases. And I'm going to start at the most basic level possible, and we're going to go pretty rapidly and go I just have, I don't remember, I think maybe 10 slides to go through. And then I'm going to pull up a lease form, and we're just going to sort of go through the lease form. And again, we'll encourage you to ask questions as we go. So what is real property? We talk about leasing real property. What do we mean by real property? Well, the law makes a basic distinction between real and personal property. And real property is essentially land and whatever is erected, growing upon, or affixed to land. And those things that are affixed to land, we call fixtures. And what is personal property? Well, personal property is just everything else. And so when we talk about real property, we talk about leasing of real property, we're talking about leasing land, and then whatever's erected, right? Buildings, whatever's growing upon it, crops and trees, or something that's affixed to it. And it's useful to take just a second to think about what it means to own real property. I think a lot of people think about this in a way that isn't particularly helpful. They think about it in terms of the 0-1, right? I own it or I don't own it. And when you start thinking about leases and other sorts of instruments of property conveyance, then it's more helpful to think about it in a little bit more nuanced way. And that is to think about property ownership as a collection of individual rights. And so when you own property, really what you own is the right to do things on or with that property. So for example, the right to erect a structure on it, right to build a house, the right to live on it, the right to grow crops on it, the right to exclude others from coming onto it. All of that bundle of individual rights is really what constitutes property ownership. And the reason why I say that this is useful is because you can transfer some of these individual rights to other people. And so the analogy that attorneys like to use here is this collection of rights is like a bundle of sticks, where each stick represents a different right. And just as you can take an individual stick out of that bundle, you can do the same thing. You can transfer those individual rights to somebody else. And so thinking of property ownership in this way, as opposed to this 0-1, you own it or I don't, makes it a lot easier to understand the legal ramifications of things like property leases. And so, and that when you talk about transfer of rights, those transfers can either be voluntary, right, as it is in the case of a lease, and sometimes they can be involuntary. So, for example, zoning restrictions is an example where the government comes in and says, okay, you know, we're going to impose a zoning restriction that says this land can only be used for residential purposes. And so the government is taking sticks out of those landowners' bundles, the right to operate a commercial enterprise on that land, for example. And so they're removing those sticks from that bundle. And so those transfers can be either voluntary or involuntary. Okay, so what does it mean? When we talk about a farmland lease, really, what are we talking about? Well, we're talking about a transfer from the property owner or landlord to another entity or person, the right to use and possess that real property for a defined period of time and contingent upon that tenant meeting a specified set of conditions, including, probably most importantly, the payment of rent. And so if the tenant fails to meet those conditions, then the landlord has the right to revoke that right to use the property. Um, okay, so leases of land in Tennessee anyway can be either oral or written, right? We can have an oral agreement to lease property. That is valid, but it's limited. It's only valid for a year. You cannot have an oral lease for real property in Tennessee that lasts for longer than 1 year. There's an old common law principle known as the Statute of Frauds that says any contracts that can't be fulfilled within 1 year have to be in writing in order to be enforceable. And also any transfers of real property have to be in writing to be enforceable. And so that statute of frauds applies to leases. So in order for a lease or oral lease to be valid, it can only be valid for up to a year. The way courts have construed oral agricultural leases is that they are presumed to be a 1-year leases with automatic 1-year renewals. When we look at the lease form, we're going to talk a little bit about renewals, but note what that means. That means if the landlord or tenant doesn't cancel that lease, they don't do something to cancel it, then it's presumed to renew upon the same terms and conditions as the original lease. And there becomes a question of, well, so if I'm obligated to exercise this right to cancel the lease so that it doesn't automatically renew, when do I have to do that? And the law is really actually not very clear in terms of when you have to do it. There is one Tennessee case. It wasn't an agricultural case, but it was an oral lease. It was actually a holdover from a written lease, but it operated as an oral lease, and the court said that the notice had to be given at least 6 months prior to the expiration of the lease term. And so it's not entirely clear how a court would view a situation where someone was in an oral agricultural lease in Tennessee and they didn't give this notice that they didn't want to renew the lease, prior to the last 6 months of the term. And there are also questions about when the term of an oral agricultural lease actually begins. In fact, we have, I've forgotten this, I should put this in the resources, but we have a publication that specifically looks at termination of oral agricultural leases. So Iris and I will try to remember to put that in the resources in case you're interested in that issue. And so even though you can have oral agricultural leases in Tennessee, we would strongly recommend that you have a written lease, and that the uncertainty associated with first, the limitation on the term is one aspect, and the other aspect is this uncertainty in terms of when the lease begins, when it expires, how you terminate that lease. Are a couple of reasons right off the bat for why written leases might be superior to an oral lease. There are plenty of other reasons as well. And just sort of, again, a broad outline, broad strokes here, those written leases can help prevent or resolve disputes because they may limit misunderstandings due to failure of the parties to adequately consider and or explicitly agree on the lease terms. Written lease can help preserve the terms of the agreement in case either party dies, becomes incapacitated, or just forgets what they might have agreed to. Also, they provide documentation for tax purposes, and they allow for a more complete agreement. I mean, there's no way that you can specify a lot of detailed terms in an oral lease and expect both parties to remember those like you can with a written lease. And so you allow for a much more complete agreement, right? The parties are going to think through and negotiate and hopefully understand a lot more of what they're agreeing to in a written lease than they would with an oral lease. Um, and my last point on this is so what happens if a lease is silent on a particular issue, right? So if you had an oral agricultural lease and the only conditions that say the only terms you really talk about are the rental amount and the term, and you really don't go into a lot of other details. So what happens if an issue comes up that's not provided for in that agreement? And it would be true for a written lease too. So what if there's an issue that comes up that's not provided for in the written lease? Well, what a court would do is they would apply the existing law, or if there is any, that governs that particular issue. Uh, Problem with that is the first is sometimes that existing law can sort of be surprising. It may impose a burden on the landowner or tenant that they wouldn't have agreed to accept had they known about it. Um, and the second is the most likely situation is that that existing law, there either isn't going to be any or it's going to be unclear. How it applies to your particular situation is going to be unclear. And so you're going to have this situation where no one really knows what's going to happen, right? You can go talk to each party, can go hire attorneys and talk to attorneys, and the attorneys are going to say, we don't know. The only way to really resolve this, the only way to answer this question is through a trial, and that's obviously not going to be um, a particularly advantageous situation for either party. And so what will happen if you do not, if a lease doesn't have provisions that deal with a particular issue and that issue arises, the most likely thing is the legal ramifications are going to be very unclear. And so you're going to have a great deal of uncertainty to work through. And it may not be, if the parties can agree, then that's one thing. But if they can't, then it may be difficult or expensive to work your way through the application of the law to that particular issue. Okay, so I've given variations of this talk a number of times. And I always talk about the advantages of a written lease, and typically I sort of stop there. We go through some generalities. Maybe I give a few examples of particular areas where, for example, the existing law might be surprising to the parties, and there are good examples to say, well, I'd prefer to deal with this differently, and so that's an advantage of a written lease. But today, since we have a little bit more time across these three sessions, we're just going to pull up a form lease and go through it. And I'll again encourage you, feel free to unmute yourself and ask questions or put them in the chat box. And Iris, if Iris sees anything come up in the chat box, she'll interrupt me and we'll talk about those. And so where I'm pulling this form lease, and by form lease, I just mean it's a pre-printed lease available for anybody to use, right? So it's not tailored to any particular circumstance. And that's, oh, I shouldn't have clicked on that. Let me, an easier way to do this, if I end the show and just pull up. This is that website, that Ag Lease 101 website. And it has a number of lease publications and lease forms. And it's I like this site because it has different varieties of leases, so it doesn't try to combine too much into one lease. You see some form leases out there that try to be everything at once, and they become sort of difficult to read because there's so many optional sort of provisions in there. And so they've got specific leases for different situations, but they also have a guidance document that goes with that lease. And so we're going to look at the cash farm lease, but you see there's a 31-page little document that goes to support that lease. And these were all created pursuant to a risk management grant by extension professionals and a variety of institutions. And so, they're not perfect leases, but they're good leases, and they're basic and they're written for individuals to use. And so these aren't form leases that an attorney would start with necessarily. these are meant to be usable by landowners and producers. And so they largely avoid legal jargon. They're just pretty basic, and they try to be, you know, fair, right, middle of the road sorts of things. And so again, we're just gonna look at this cash farm lease, and let me pull up the PDF here somewhere.
Chris, we have a quick question.
Okay.
Are those leases you just pull out, are they state specific?
No, they're not, and that that can be an issue. It's you know it generally isn't. You have to be a little careful when you move into certain specific areas. These leases are basic, and again, if this is if you're going to pull, I mean, one of the questions I have for myself is to that I might anticipate someone's asking is, you know, is it okay to use a lease form? So if you're a producer or a landowner and you really don't want to pay an attorney to draft a lease, draft and negotiate a lease, you know, is it okay to pull one of these off and use it? And my answer would be, well, it's certainly better than an oral lease to start with. Now, whether or not it's worthwhile to pay an attorney to draft and negotiate a lease, you know, it really depends on how important that leasing situation is to you, and how likely you think there are going to be problems associated with that. And it's sort of the same answer in terms of state specific. You know, there is unlikely anything in these leases that are a problem because they're pretty general terms. If you wanted to negotiate and have a more detailed and specific lease, and we'll go through some of those examples of where these lease agreements or this lease agreement is rather vague. But if you want to go into more details, that's when it would probably become a little bit more important to worry about specific state, you know, the differences from one state to another state in terms of the law. Uh, and just quickly, one example of that, one of the areas that this lease that doesn't have a lot of detail is in terms of remedies in the event of a breach, right? So if you were to go enter into a commercial lease, you know, negotiated by some high-priced attorneys, then there's going to be a very detailed and long section about exactly what happens if the tenant breaches some term of the lease, right? If they fail to pay rent or they do something that violates the term of the lease. And that's not in this agreement. And that's an area where there are differences from state to state. So how that detailed section would be written would vary from one state to the next. But this lease is so general and it doesn't really go into that detail, it's really not an issue. That was a very long answer to a short question. No, they are not state specific. Good question, though. So starting, it starts off with, first of all, there's a reference to those guidance documents, which is good. Then there's some of the, you know, more disclaimer, because again, this was produced by some extension people. So typically that wouldn't be there. And by the way, if I was a landowner and I was going to use one of these documents, you know, this is a fillable PDF, but probably what I would do is take it and convert it to a Word document, and then that give you a lot more free reign to play with it. Now, there's a disadvantage to that because in dealing with the other party, you know, right, there may be some comfort level in knowing that this is an extension publication, because there's some assurance that it represents an attempt to be fair to both parties. And so it may be that you're better off leaving this as a PDF and just hand marking up the changes you want to make. So if there's a section that you don't like, it's just go in with a pencil, mark it out, change it to however you want it to read. If you do that, make sure that both parties initial, when they sign the lease agreement, make sure that both parties initial any changes you make. But doing it that way, maybe you don't cause concern from the other party that you've changed something that makes it less fair to them. Up to you. Okay, so that's the first couple of and then we have there's the date at which it was executed, um, and then the parties to the lease agreement. Um, it calls the landowner owner, and it calls the tenant operator, which is a kind of a strange choice to me, but okay. Um, and it has space for this for not only the owner and the operator, but also their spouses to sign. It's not required. It is a good idea. It could save you some problems, right? In the case, so if you're a tenant, having the landowner's spouse sign might save you some difficulties if there's a divorce or a death. Right, having that other signature there is good. It's not required. The lease would still be effective without it. It just may eliminate some difficulties. Ask for addresses. Oh, and one other resource, and this is in the resources slide, is if you do want to hire an attorney, um, you could always take this form, mark it up with the things that you want, put in your business terms, all that stuff, and use that when you go meet with that attorney. That might well save some time, and of course, saving time saves you money in terms of dealing with attorneys. And so, one of the resources that I listed was a document called "Finding and Working with Professionals," that is meant to provide guidance on interacting with attorneys, specifically within the estate planning context. But a lot of the discussion there would be equally applicable to hiring an attorney to help you with a leasing situation. One other thing to be careful of is this is written as if, well, I guess that specifies. Um, are you entering into this lease as an individual or as some form of an entity, right? So if you formed an LLC, if you're farming through this LLC, then you're going to want to make sure that the LLC is the entity that is listed as the owner or the operator, and that you sign as an whatever your role is within that entity. So if it's a corporation and you're the CEO, then the corporation would be listed here as a party. And when on the signature lines at the end, you would always want to make sure that if you're president or CEO, you sign as that officer. You don't sign just as your name. And that's true for any legal document if you are operating as an entity. You always want to make sure that you're executing that, as whatever role you have, not as an individual. Um, all right, so the first then provision here is the property description. A lot of ways you can handle a property description. Um, for one thing, if it's for an entire parcel, you could pull a description out of a deed, and you could either type it into this section, or if it's long, you could just attach it as an exhibit. So you could just write, see Exhibit A here. You could write Exhibit A at the top of it, and make a copy of the property description from your deed. Write Exhibit A at the top of it, staple it to it, boom, you're done. Now, if it's not an entire parcel, then that might not work as well. But you could always, you could draw a map. You maybe can specify with words. I mean, the key here, there's a lot of different ways to do it. The key would be for a third party who wasn't a part of the discussions, hasn't ever stepped foot on the property, can they take this description and interpret exactly what property is being leased? That's the goal you're shooting for. Um, and again, it might be as simple as to say the Christopher Clark farm on such and such road. That might be sufficient. It just depends on your particular situation. Okay, let's see. Okay, so then we're moving into what this particular form calls the general terms of lease, and it starts with the leasing term. So that first sentence provides that length, right? So for X years, of course, it could be months. There's a lot of different ways. You can specify just about any term you want, but it's got the term and then that date in which the lease starts, the date that the tenant can take possession of the property. It doesn't have an expiration date, which is a little bit unusual, but okay. And so again, every lease, should have some variation on this first sentence. Um, then the second sentence really has to do with what happens at the end of that original term. So it has to do with lease renewal. And what this particular lease does is it provides that the term automatically renews on a year-to-year basis on the same terms and conditions as the original lease, um, unless either party gives the other party notice at some point and you specify the number of days prior to the expiration of the lease. Um, Again, that you don't have to. This sentence is purely optional, right? You don't have to have any specification about renewal. You could have an option to renew. You could grant the tenant an option to renew upon certain terms and conditions. Do basically anything you want here. One thing that this section doesn't talk about, or it's not anywhere else in the lease, is what happens if you have a holdover tenant. So what happens if the lease expires and the tenant refuses to leave, right? Refuses to give up possession of the property. Maybe that's not as big of a concern in terms of a farm as it would be in terms of a house, but that's not something that's in this lease agreement. And if I was a landlord, I might want to have some specific provisions. A lot of times you'll provide for the rent to dramatically increase and also give you rights to have them removed from the property. This 2B here, section 2, subsection B here is a rather unusual provision. And I think it's in here because of the way that they treated the renewal. The way they made the renewal automatic is they have a section in here to provide for a written request to review the terms of the lease. And it's a bit strange to me. That's probably a section I would just delete if I was using this. C, so we're moving into for this C here. You guys have looked at contracts before, and you see that typically there's this. Often they come at the end of that. There's just this section, paragraph after paragraph, or this long legalese, and attorneys call that boilerplate, and that's just these provisions that are. They're in almost every agreement. Okay, go ahead. If you have a question. I'm not sure if that's a microphone problem. Okay. I'm not hearing you. And so what this subsection C here just says, if you're going to amend or alter the lease, it has to be in writing and signed by both parties. There's also a legal provision everyone should be aware of, known as the parole evidence rule. And that is when you reduce an agreement to writing, right? So when you have a written instrument for a contract or a lease or anything like that, that is deemed to be the substance of the agreement. So a court would not allow you to introduce testimony that says, okay, well, we actually, even though the lease says this, we actually agreed on something else. That's courts won't listen to that testimony. They will allow you to introduce testimony to interpret a provision of the lease agreement. So if there's something that's ambiguous about the lease agreement, then you can introduce evidence to say, well, we negotiated, this particular resolution of that issue, but you can't introduce any evidence that would contradict a term of that agreement. And so if you do have a written document, you want to make sure that you're including every aspect of whatever the agreement is between the parties. The next section, no partnership attended. Again, we don't want leases to be treated as partnerships because that implies a whole another level of legal obligation. It's not really typically a problem in a cash lease. It would be a much bigger issue in a crop share or a shared lease. E is a good example of one of those things that you might not expect in a oral lease. So it provides that if the owner should sell or otherwise transfer title of the farm, such action will be done subject to the provisions of this lease. So under the law, so if there's no provision in the lease to the contrary, the owner sells the property, that new owner is not bound by the lease, right? So they can come in and basically cancel your lease, terminate your lease. And that's a problem for tenants, and particularly where if you have growing crops, right? And so this provision says the opposite, that the new owner is going to be bound by the terms of the lease. And to truly make that operative in Tennessee, you really need to have the lease notarized and recorded, because that process of recording the lease, which is you file a copy with the county register of deeds, just like you would with a deed. that process is what gives that buyer notice. And so that's what's going to make it binding on that buyer. Right of entry, again, here's another one that might be surprising in terms of an oral agriculture lease. If you don't have a provision in the lease that addresses the issue of the landowner's right to come on the property, then you don't have a right to come on the property during the lease, right? So you are transferring. What that lease does is it transfers exclusive possession to the tenant. And so if you don't have something in the lease agreement that reserves a right to go on to the property, then you're not, as the landowner, you're not allowed to without the tenant's permission anyway. And so this provides and again, there are all kinds of different ways that you can resolve this and give landowners rights to come on the property. And this is, a reasonable example. So the owner, as well as agents and employees of the owner, reserve the right to enter the farm at any reasonable time, to consult with the operator, to make repairs, improvements, inspections, and after notice of termination of the lease is given, to do tilling, seeding, fertilizing, and any other customary seasonal work, none of which is to interfere with the operator in carrying out regular operations. And so you see the careful sort of balancing of the interests between the two parties there. Now, from the landlord's perspective, if you don't have a written lease, the tenant can sublease that, right? They can basically transfer their interest in the lease to another party. And so one of the advantages from a landlord's perspective of having a written lease is you can provide a term in there that says, no, you can't do that. Or at least you can't do that without my permission, which is this particular, this particular provision explicitly forbids any subleases. As a tenant, I would argue that I should be able to sublease with your permission, and you shouldn't be able to unreasonably withhold that permission, right? So if you're a producer, and say this is a 5-year lease, what happens if you become ill and you can't farm? Or something happens to keep you from farming halfway through the lease. Well, if you don't have the ability to sublease it, then you may be stuck in paying that rent, even if you can't farm the land. So, I would argue that from a tenant's perspective, that it's reasonable to say I should be able to sublease the land, and you should, given the landowner's consent, and you can't unreasonably withhold that consent. So if there's a reasonable reason why I'm subleasing it, and the entity or person I'm subleasing it to is a reasonable replacement for me, then you should be okay with that, landlord. Binding on heirs, yeah, this is more typical, right? Just to make sure it's binding on it on every. So if something happens, if one of the parties dies, then what happens? And again, similar to the sale of the property, you'd want to record this to make sure it's binding on those other parties. Very few leases are actually recorded because it's not, well, I won't say very few. Most leases are not, because it's typically not that big of a concern. But if it is, then you definitely should do that. Then this lease form has a blank here where you can add additional terms you might want. Let's catch it. We'll talk about it at the end, a couple of things that I think is missing. Then the next section is land use, and this is a very important section. And it's a little strange how they do this, because they really sort of break up the land use in two places. Because at the very beginning, there was a section that really is the whoops, it doesn't work very well.
Chris, we have another question. So
Okay.
who holds an agreement with the leaser?
So you can, there are two possibilities in terms of what you do as a tenant. You can assign the lease, and you can sublease the property. So an assignment, actually, then you transfer as a tenant, you transfer all of your right, title, and interest in that lease. And so effectively in that situation, the landlord and that assignee are in the lease by themselves, and you're removed. When it's a sublease, you're still in there, so you're typically still going to be held liable. So you effectively are leasing your interest to a third party. And so the landlord typically will still be holding you responsible. So the relationship in a sublease is between the tenant and the sublessor. And again, it's an argument why I would say from a tenant's perspective, if I'm still liable on that lease, is another reason why the landlord should consent to me being allowed to sublease it. I mean, the big concern there is trusting the sublessor in terms of the, you know, are they going to not do anything to injure the property? And that relates again to land use. And so another good question. And so the land use here is broken up because here in the property description, it says to occupy and use for agriculture and related purposes, which is a pretty broad, from the landowner's perspective, that's a pretty broad land use provision there because there are all kinds of things that could be related to agriculture. And so again, it's a good example where as a landowner for this, I would probably want to narrow this provision down and be much more explicit about what sort of land use is permitted. And then because then in this section, it specifies, you see it breaks down the land use by acreage. But the categories are sort of broad: row crop, small grains, hay, you know, so it doesn't go down to the crop level, for example. And so it's, you know, this lease is walking sort of an uneasy balance between providing flexibility in land use, but also specificity from the landowner's perspective. Um, and when you think about land use, you can think about that there's sort of three possibilities. One here is a particular land use expressly permitted under the lease, which in this case that would be agricultural and related purposes. It's expressly prohibited under the lease, right? And so we really don't have anything any use that's expressly prohibited. Although there's the language in here about, you know, it looks like we're specifically talking about the hunting, trapping, or other, but again, that's not in the lease clause, the land use clause. Um, and then you've got all land uses in between that are neither expressly permitted or expressly prohibited. And those are the gray area that you want to be careful about. And of course, you can't specify, you know, you can't prohibit every possible. And so it's in my mind, it's a really good practice to be very careful and specific about what land use is expressly permitted, because that gives the court that guidance to say, well, you know, they clearly thought about this issue. They very carefully phrased and specified, defined what land use that they want to have happen on the property. And so it makes the court much more likely to say, okay, what you're talking about isn't that, you know, wasn't expressly defined, and so it shouldn't be allowed. And so in my mind, the best way to get to clarify that uncertainty about those things that aren't either expressly permitted or expressly prohibited is to be very clear and definite and detailed about what is allowed. And that's why I'm not crazy about this lease. But again, this is an example of trying to balance, and that was really from the landowner's perspective. This is an example of trying to be um, brief, but also sort of middle of the road in this form agreement. And again, another example of where maybe there's value in hiring an attorney if you're not comfortable with the sort of land use. Another interesting part of this, and so this land use says, okay, we're gonna, you know, the land's gonna be used in this way, the acreage is gonna be allocated in this way, and it provides though a little bit of flexibility. If it is impractical in any year to follow such a land use plan, appropriate adjustments will be made by mutual written agreement between the parties. And so that raises a question of, well, what happens if the parties can't come to a mutual agreement? And what this lease does is sort of interesting. Is so if you go to this clause here, this arbitration of difference clause, this is any differences between the parties as to the rights or obligations of the lease that are not settled by mutual agreement after thorough discussion shall be submitted for arbitration to a committee of 3 disinterested persons, one selected by each party hereto, and the third selected by the two that they select, the first 2 selected. And then that committee's decision shall be accepted by both parties. And so it provides this dispute resolution mechanism, which is arbitration, which, you know, basically is saying the party's going to be bound by the decision of these 3 other people that they get selected. So it's good. I mean, right. That's going to be a lot less expensive than going to court, having a trial over these issues. But um, it also could be maybe a little clear. I'm not crazy. The any differences part comes across as a little broad to me. I like the idea that those places where the lease says things are going to be made, decisions are going to be made by mutual agreement, and if we can't mutually agree, then we're going to go to an arbitration here. But just to say that any sort of differences between us, any arguments are going to go through this process, I'm not crazy, right? If I'm the landowner and the tenant's not paying the rent and they're disputing, they're saying for some reason they don't have to pay the rent, do I want to have to go through this arbitration as opposed to taking them just straight to a trial? Probably not. So this is again an example where this lease is fairly short and a little bit vague, and the attorney in me anyway isn't all that comfortable with some of that vagueness. But again, it's a really good document if you're not going to be in a position to specify that, to be more complete about these things. And then I'm going to sort of speed up a little bit here. So the land use, again, very important provision. There's also a nice paragraph about government programs. It's the real advantage of using an ag lease as opposed to just pulling some form lease from someplace else, because there are some things that are going to be very specific to this context. Um, the rent, again, this is just a cash rental agreement, and it allows you to either specify based upon the land use or just for one overall rental rate. An aspect I do like is this schedule of rental payments. And of course, you can pay, you can set this up however you want to. They can pay a 12th every month. They can pay once a year. It's completely up to the parties. There is a provision here for earning interest on rent that's not paid on time. Again, as a landowner, I'd probably want a little bit more than that. I'd probably want to have some sort of late payment penalty. Um, Specifies an address for paying rental payments if it's not to the address listed above. Provides for liens against the crops. Again, this is available under state law, so this is just sort of, again, boilerplate. Then it goes to this fifth section is entitled Operation and Maintenance of Farm. And it's very common in leases that you have a section that specifies the tenant's obligations, the landowner's obligations, and that's what this does. And so this first section are the tenants or the operator's obligations. Um, to maintain the property, to control noxious weeds, to control soil erosion, to avoid damaging the property, to pay all the costs of their operation, um, repairs. We're going to come back to that. To provide the owner with documentation in regard to yield or production information for crop insurance or USDA commodity programs. Again, a nice provision that's in there because it's an ag lease. Then the next subsection here are the landowners or the tenant, or the landlords obligations. And landowners required to replace any structures that the tenant is using that are destroyed. A lot of times, this lease doesn't mention insurance. That's one of the things that I would say I would want to add. Um, if I'm a landowner, I'm probably going to want the tenant to have liability insurance. If I'm the tenant and I'm relying upon some structure on the property, I probably want the landowner to have fire insurance on that structure so that I have some guarantee that it's going to be replaced if something happens to it. And then the lease is a little bit weird in my mind, um, in terms of it requires the landowners essentially to be responsible for repairs. Um, and that's not unusual for structures in a farm context. It's, again, this is another section that's a little ambiguous to me. Um, I'm not exactly sure what all falls under the normal maintenance and repairs category here for a farm lease. And so I would not be entirely comfortable with these three sections here that again basically are putting this obligation on the landowner. Um, when we defined real property, we said fixtures are part of real property. So an issue in a leasing agreement is what happens if a tenant installs some fixture, right? So as a tenant, if you're renting a house and you install something on that house, you put in new hardwood flooring, for example. Well, that when it becomes attached to that property, it becomes a fixture, and at that point, it's the property of the landowner. right? You've installed real property. The landowner owns the real property, so you don't have a right to remove that hardwood at the end of the lease term. And one of the cases we talk about for in the farm context is irrigation equipment. Is that a fixture or is it not a fixture? And there's some tests on there that basically have to do with how easy it is to remove move whatever article we're talking about. But this has, if you don't have a written lease, then you've got some real issues in determining what happens there. This has a nice section, a couple of sections actually dealing with these improvements. It allows the tenant to make some removable improvements. It allows them to remove them under certain circumstances, and it has a schedule for how how they're going to divide up the costs if those are improvements that aren't going to be removed. Um,
We have a question on that related to that. Is there a way to structure a lease to permit the tenant to build on the property?
what was that? Build on the property?
To permit them to build on the property.
Um, yes, right. I mean, the short answer is going to be there's almost always a way to do it. It's not when you say to build on the property, and so that structure is going to remain on the property after the lease expires. I'm assuming is what you're talking about, and this lease actually deals with that exact issue. Yeah, we'll see. So I don't further agree. So first, there's a move. Um, yeah, at some point, yeah, I thought, yeah, here it is, the capital improvement section down here. Now, I think so. This isn't a specific building. This has to do with conservation structures, which is close enough. And it has a table that sets out how they're going to deal with the financial ramifications, right? So if the structure stays after the expiration of the lease, presumably the landlord then is going to compensate the tenant for their expenses in constructing that structure, whatever it is. Uh, some boilerplate, not to obligate. Um, we just talked about capital improvements. And again, so a couple of different options. One is for some things, the tenant may be able to remove those. And so even though technically or legally those might be fixtures that under normal circumstances a tenant wouldn't be allowed to remove, with provision in a written lease that overcomes the natural the common law to say, okay, in this particular instance, we're going to allow the tenant to remove those. Or if they're not going to be removed, we're going to specify a series of, a payment to compensate the tenant for those. An issue that maybe is increasingly important is what happens if there's some sort of solar opportunity for the landowner. So if this is if it's a longer term lease, if it's a 5 or 10 year lease, and the landowner is approached by a solar development company, what this basically does is it gives the landowner an out. Right? They essentially, when you read through this, you see that they basically can cancel the lease in order to take advantage of that. And again, that maybe that's as a landowner, maybe you want that. As a tenant, maybe you're not okay with that. But you could always go through and either just take a pencil or a pen, excuse me, and mark up this section. You could delete it entirely. If you do it, make sure you put your initials. You could revise it however you want to. Um, and if you're really concerned and you moving it, this is a very important thing, then that's where you might want to hire an attorney to help you work your way through what the options are and what the ramifications of those options are. Um, Section in here about environmental issues, and this is basically just comply with the law. Um, Although it does provide for indemnification of the landowner for environmental cleanup and restoration. And what indemnification basically means is the tenant is saying they're going to be responsible for any and all costs incurred by the landowner. Then the really the last section was that arbitration clause we talked about earlier. Then this lease does have kind of they put it at the end as opposed to with the other. There's a section that allows for flexible rent payment, and so again, it's not earlier, but the reason why they did it is because it just makes it easier to mark through this if you're not going to use that. Um, and so it goes through a variety of different methods, and we've got signature lines. Again, if you're operating as an entity, you want to make sure it specified that, so you wouldn't just you wouldn't go on here where it says entity and just sign your name. So if it's a corporation and you're the president of that corporation, you would want to change this and make sure it says president of whatever that corporation is. And that, again, true for anything you sign. Because if you just sign as your individual, just as your name, then there becomes a question of, are you entering into that as yourself, or are you entering into that agreement as the entity? And to preserve your limited liability, you want to make sure you're entering into it as the entity. And then this is the notary. So again, if you think you're going to record the lease, you would notarize it. If you're not going to record it, you do not need to notarize it. It's still perfectly valid between the parties. And again, what that notary and what that recording does is it helps you make that lease effective against third parties. So if something happens and the landowner sells the property, then that recording the lease is going to make the lease effective against whoever buys the property. It doesn't affect the relationship between the landowner and the tenant. Okay, that's been 50 minutes, which is 5 minutes past. And so I'm going to stop here, but it's to answer any questions anybody has.
We have one question. So does the owner hold the original lease with the live signature? I don't really understand what that means.
Yeah,
I'm going to repeat it one more time. Does the owner hold the original lease with the live signature?
I think so what they're asking is, if you sign one document then you just make, right, so each party has signed one document, so there's one lease that has original signatures, and then there are copies. um, One thing you can do is you can sign two versions, so each has original signatures if you want. um, that's, yeah, if I was the landowner, I would want to be the one that held on to the original agreement. But you know, a copy is going to be valid. There can potentially be issues with proof, and you'd prefer to have the original. But it's going to be very difficult. It would be typically very difficult for someone to claim, I didn't sign it. So we typically don't worry about that quite as much. But again, it's also a good idea to maybe have someone in the room when both parties are signing it, right? So you can also have eyewitness testimony. Is a carport considered a fixture? Yes. I can lay out, if I could remember, I'd have to pull up the slide to pull the exact definition. But anything like that is permanently affixed, anything that the basic test is of a fixture, is this something that is meant to be a permanent attachment to the land? And of course, when you talk about real property, what does permanent mean? But if there's no value, if you couldn't take this fixture and take this item and move it and use it someplace else, then it's a fixture. And so if this were, I guess you could have some sort of portable carport, but if you're constructing the carport, that's where there's no easy way to remove it from this property and use it someplace else. Yes, it is a fixture. And so that's why, irrigation is such a very interesting one, because if you're talking about having pipes that are above ground, that are easily movable and that you do move to irrigate, that's one thing. Center pivot, center pivot, certainly there are going to be aspects of that wellhead and other aspects that you would never move. Moving a lot of that center pivot equipment, technically feasible, but it might be more expensive to move it than it would be worth. And then the short answer, by the way, in Tennessee is it's not at all clear. And when you look across the U.S. and other states, um, again, you see courts trying to balance what is and what is not a fixture in terms of irrigation equipment, and a lot more of it might be considered a fixture than you might think. Any other questions?
I'm not seeing any questions so far, but if you do, just feel free to unmute yourself or put in the chat box. while we're waiting for any more questions, thank you, Chris. I think this is really useful to look at a sample and then go through it. And I'm gonna ask everybody to answer these 2 questions to help me record feedbacks. And this is our last session of Farmland Leasing. If you're interested in further workshops that developed by University of Tennessee Managed Program, feel free to Google search UT Managed Program, and we update those workshops when it's happening. All right, so I don't see any further questions, and thank you all again for joining us for the short webinar series.
Thank you.
Thank you, Chris.
It's fun.